My lord, in regard to item 16, I have taken consent from my learned friend.
Ah.
My lord, just 2 weeks time to file the affidavit.
16. Okay. Oh. On the prayer of Mr. S. Dutta, learned senior counsel for the respondent, Silchar Municipal Board.
My-
Matter stands adjourned to enable the board to file an affidavit in opposition. List this matter.
After 2 weeks, I will take marriage.
Then after vacation?
Vacation, one chance may be taken.
We might have urgency.
No, after vacation, let us not take chance. Immediately after 21st of October.
My lord.
God bless me.
Omelette.
22nd.
26th.
Mr. Dutta,
Yes.
some other cases yesterday,
My friend,
Ah,
Mr. Shayola told me.
otherwise we cannot proceed without
Yes.
children's.
I'll sit.
Yes.
God bless.
I beg to mention for listing a review petition, my lord. We are the writ petitioners, my lord.
Ah.
And review petition filed by the Union of India, my lord.
Ah.
Regarding, my lord, biometric, my lord. Biometric of fingerprint, my lord. Petition was selected for the Central Armed Police Force, my lord.
Ah.
But their appointment not be given for mismatch of their biometric, my lord.
Ah.
Your lord should direct them to,
Okay, that Kerala case.
yes, my lord.
Then,
Yet not, my lord, completed process, my lord. They filed review, my lord.
okay,
On what is the, my lord?
Huh?
On 18, my lord.
18, 19, give it it.
My lord, obliged.
May I please your
Yes.
lordship? In regards to item number 10, an affidavit in reply was filed on 12/9/2024,
Hmm.
which may be called for.
Okay.
Your obliged.
For motion B, item number 1.
Scan copies.
May I pray one thing that co-accused is granted bail on 28/9.
Hmm.
So last 10 days back. Along with that record, if your lordship listed.
Anything happened thereafter? Any updated?
Thereafter, as per my instruction, no.
Charges are yet to be from lordship. One of the co-accused lordship did not engage advocate. That is why lordship charges are not from
If
lordship.
not engaged advocate, you'll have to engage amicus. Anyway, it is submitted, this is an application under suspension. It is submitted by Mr. Ahmed that co-accused has been granted bail by this court on
On 29/8/2024.
29/8/2024, and the scan copies of the record is available with the said bail application being bail.
DA number 509 of 2022.
Written packet since dispose of accordingly registry accordingly accordingly registry to list this matter on.
Lordship allows only 7 days time.
That's why we're on. That's why I'm asking on.
Lordship, any date after 10 days, lordship.
After 10 days, give a date. 30. You'll have to copy and paste. 30th of September 2024. In the meantime, the DRI
Yes, lordship.
DRI may file their objection.
Yeah, please.
Yes.
My lord, in this case, my lord, we received instruction, we are also supposed to file a affidavit, my lord.
Or repeat.
Otherwise, my lord,
dispose
this,
it of.
concerned officer is not present today, my lord. He is from Jorhat, my lord.
Let appeal is to be decided under section 250
Lordship.
within a period, specific period.
Lordship,
There is a guideline issued.
my lord.
So we'll pass an order that it will be disposed of within specified period, and in the meantime, this interim order will continue. That's all.
Lordship, in fact, my lord, the
Similar order has passed by
my lord,
court
in
bench.
fact, the recovery proceeding, lordship. That was, my lord, initiated based on, my lord, guideline issued by the, my lord, the boards, Central Board of Direct Taxes. So, my lord, we are saying that, my lord, since board has issued instruction, my lord, for recovery proceeding, so accordingly we initiated the proceeding. Now that's instruction precisely, my lord, we have.
No, understand, but
My lord.
admittedly, decision appeal
My lord.
and 250, what that provision?
My lord, they have not filed any stay application before the, my lord, appellate authority, my lord. They have not filed. That is the appropriate forum, my lord.
They have not filed before the appellate authority. They have rather filed before the assessing officer.
My lord, that was.
Is that
the-
it?
My lord,
So that, forget about that. Why, let them go to the appellate authority.
Your Lordship.
Let the appeal be decided. You have a mandate of deciding the appeal within 1 year.
Yes, Your Lordship.
When appeal was filed.
my lord, page 303.
25/8/2023.
25/8/23. Now 1 year is over. This is your mandate. We'll give you a month's time to decide.
Lord, appeal may be decided, my lord.
But that's all, because there is a provision. If you don't decide and insist on recovery also, how will it do? We'll dispose it off. Today or Tuesday.
Otherwise, my lord, I have already served copy to the, my lord, my friend, my lord. Only difficulty today, my lord, the officer is from Jorhat, my lord. He could not manage, my lord. So we'll file it by Monday.
This
itself.
is an wastage. Why should he come? This is, you are sitting over the matter for 1 year. The
Look.
act mandates it should be decided within 1 year. For that, they are taking an advantage. They are coming here for a stay, and we have stayed the recovery.
My lord, recovery is stayed till the, my lord, the order has been passed by the assessing authority, my lord. That has been passed, my lord, on, my lord, 12/8/2024, my lord.
Ah.
It is against the stay application for the subsequent letter, Your Lordship, not against the original stay applications we had filed in the month of January.
Why have you gone to the assessing officer who has passed this order by filing this appeal? Your bona fide is doubtful. Why didn't you file an application before the appellate authority? There is law which says it is permissible, though there is no specific provision. Isn't it?
Lordship, let me, if it will be taken on record, we'll file it by Monday, my lord.
Okay,
We have
list
already
this on the
served
prayer of
copy.
the learned council for the parties, list this matter on Tuesday.
Your Lordship.
Yeah, well.
Interim order may be continued.
Interim order pass shall continue till then.
Apply.
Okay.
For last order, Your Lordship.
Yes, affidavit file.
If it, no, if it. There is the Panchayat Lordship.
Yes.
Okay, no?
Lordship, today, even today morning, I have received the original records. For this.
No, we do not want record. What is the order? Affidavit be filed on or before the date, next date. That is 13/9/2023.
Today I have received the.
We do not know.
As per records, petitioners.
No, we do not know. We have asked you to file an affidavit. That's all. With certain specific point.
Lordship,
And that affidavit was to be filed by today.
Lordship,
When will you file it?
Lordship, Wednesday.
Wednesday? Okay. It is submitted by the learned counsel for the petitioner that though the instruction has been received, however, the affidavit could not be filed in terms of this court's order dated 28/8/2024, and therefore, full stop. It is prayed that the department shall be able to file their affidavit by date Wednesday, 28/2024, in terms of this court's order dated 28/8/2024. List this matter accordingly on Thursday. Thursday is give the date. Yes, where is the order? What it says?
It was relating to illegal extraction of minor mineral from Madhura River. So initially PIL number 18 of 2008 was filed.
Hmm.
There, this honorable court gave complete ban that
Hmm.
no extraction can be done at all. Even for government purpose also no extraction could be done.
Hmm.
Thereafter, they filed a review government in the year 2013. Then
Hmm.
limited extraction has been permitted
Hmm.
only for government purpose.
Now, what is your case?
Lordship wanted to know. Our case is that Lordship, in one village, more than 21 village industries have been set up.
Hmm.
Stone crusher unit, then steel industries.
Is it relatable to Madhura River?
It is not at all. It is not so related yet. Madhura River passes by nearby, but
Okay, we'll hear this matter on next Thursday.
lordship.
The prayer of the learned council for the parties, release this matter next Thursday possible? How many meters? Huh? Okay, 10 meters, Thursday. We'll decide this matter on that day. Pending since 2014. Yes, any instruction on in terms of the first method we have concluded hearing, no problem on that. Everybody's arguments are recorded. What about Mr. Talukdar? What is the?
At the end of the day, if the proceedings are to be redrawn, admittedly, my lord, we are on this side, post 1/1/2014. Then the amount which they have already received, that will be adjusted.
Definitely, no doubt about that. Why is it? No doubt about it. Can they give double benefit? No. That cannot.
Now, only thing remains, my lord, that who is going to pay the money? That is one aspect of the matter.
That is.
But second, my lord, in the second writ petition, they say that they are in occupation. But nonetheless, in our affidavit, we have taken a stand that, my lord, that the land has been acquired.
That notification was published only for entrustment of that work, lordship, to the NHI detail, lordship.
Last affidavit is of the last.
That in the year, lordship, that Mort has entrusted to NHIDCL to work that, carry out that work. Lordship.
Thank you.
Under which provision?
On section 5.
Lordship, under section 5 of NHL.
It was the central government's responsibility.
So this is not relatable to any
Yes,
acquisition
lordship.
process
Yes,
under.
yes.
Okay.
Your lordship will find it at 258. 252 of the last affidavit. 252.
No, okay, that issue is gone. That is since we want a clarification, they have clarified. Now, the question is,
Who is to pay?
who is to pay will decide. But in your case, to whom is to be paid?
Because their writ petition is absolutely silent with regard to the part and parcels over which they are not in a public interest capacity.
And where are the notices to each individual? Land acquisition notice to individuals.
Summary. Well, the earlier cases were filed by the individual.
No, we are not at this stage dismissing your petition on maintainability or on representing capital. That, forget about that. Now, how will you give you relief if you want to give you? Tell us that. To whom? Whose land is this? Because these are notices, individual rights. I am having a land, 1 bigha 2 kathas under dag number so-and-so, patta number so-and-so. Mr. BC Das is having a land half a furlong away with dag number so-and-so, so-and-so. There is nothing on this writ petition to show that notice under section 4 or notice under section 5, 6 was issued in the name of Mr. BC Das. There is nothing to say that any award was passed earlier, though approval was not taken, or no award was passed. Except passing an order that individual claim may be considered if we decide in favor, if we lay down the principle in this case, since it's relatable to the same acquisition process.
My lord, this is an offshoot of the order at page 105. This is an offshoot of the order dated 105. Of the page 105 of the writ petition. And your lordship, Before that, my lord, the individual owners has filed separate writ petition, about 6 writ petition. That was the order under challenge in this writ petition. But that was a sequel to at page 70. Separate writ petitions were prepared by the owners of the land separately in 6 writ petitions. Identical orders were passed.
It is arising out of the same land acquisition process like your case.
Same land acquisition process.
So you lay down the principle, rest is to claim individually, whatever, that's all.
Yes. This order precisely at page 105, which Learned Senior Council has just now referred to, is not put under challenge. Yes, it was put under challenge. Yeah, I'm going to the prayer portion, appearing at page 33 of the writ petition. The same writ petition, page 33. Prayer starts at page 33. Direction shall not be issued setting aside the impugn order. It is there, my lord, passed by rejecting the representations filed in terms of so and so. It is with regard to rejection of the representation.
See, I'll tell you, they preferred a writ petition, individual writ petition.
Yes.
Then their order says, say, okay, this is our claim that we are entitled for under 2013, not under 1894. So writ petition dispose of relegating the matter to the secretary. Now secretary passes this order. Now they say impugn order. This is the impugn
My
order.
lord, absolutely understood. But is it not incumbent, my lord? I'm putting a question to my. This is a court of record. They ought to have, my lord, spelled out.
They have not.
Otherwise, my
But
lord,
at the same time, we are
Yes,
also in
yes.
a writ court.
my lord.
A postcard is can be a writ petition, Mr. Borpujari.
And my lord,
A postcard can be a writ petition. Forget about this affidavit.
and my lord, at page 80, your lordship will be see.
So that's all.
Then yes,
The argument advanced in earlier case, your reply, we have recorded, everything is same.
and lordship may kindly, with my lord, with all
But
the.
in that case, we can record what is the notice, what is the DUG numbers and patta numbers. In this case, we cannot.
Absolutely. But therefore. But my lord, during the hearing of the case, my lord, parleys are going on. Your lordship, please to see. It was.
No, Mr. Das, we are not disputing anything as regards your locus standi,
Yes.
filing this writ petition. We are not on that. But we cannot direct anything that so and so be paid the land acquisition, even if we decide. What we can say is that this is the principle.
Yes.
If we accept your contention, that is contention of Mr. Sharma, that this is acceptable. And if we accept the contention of Mr. Borpujari, then writ petition goes. And if we accept his contention, in his case, we will have to say this is the land, it will be applicable to so on and so forth.
Yeah.
And in your case, we will have to say that individual, this is the principle we have laid down. Everything is to be determined in terms of the verification and entitlement of individual, and specifically make mention no amount if we at least, if we allow, not in favor of this petitioner. Not in favor of this petitioner. It is in favor of the individual. They may be party to this writ petition, they may not be party to this. This will be a judgment is rem, provided we accept.
But your lordship, please to see, my lord, at page 80.
No, then
Of the writ
it's
petition.
nothing to be argued today.
Yes. Only, my lord, again comes back to square one, my lord, that who is going to pay the money?
Why are you going to that question right now? You are not confident.
My lord,
That shows you your confidence. But we are not making it CAV. We'll try to dictate this judgment in presence of everybody. before vacation. So we are keeping it as a part
Absolutely,
on the
absolutely. My lord.
next day
It
because you
would
have
be
almost dictated the order.
It would be, my lord, concerted prayer from all of us, my lord. Lordship
My
has heard it at length, my lord.
If you lordship is pleased to hear me.
List this matter, I heard at some length, list this matter for further hearing. Your arguments are taken note of. Everything is covered. Only he said that he want to add something. So far relating to principle, nothing is required to be added.
But
Only
this-
question was in my mind that how can we give relief to this Bhumir Samiti?
Yes.
Samiti is not the
Samiti came
power,
into the
the
picture.
secretary will not get any relief.
It came into the picture that was reflected in the earlier order of
So
this
that we
court.
understand.
Yes, at page 18.
That we have seen.
Yes, sir.
That we have seen. Because you individually approached this
Yes,
report,
sir.
then it was
Relegated to
relegated to the authority to determine a question of law.
Yes.
Then authority decided. Now we'll have to decide whether the authority is correct or not.
Yes.
In his case, there was no order, but he claims this.
Yes.
So we'll have to lay down the principle of law we need not lay down the principle of law. Law is laid down. We'll have to make application which clause of the judgment will be applicable. Whether Mr. Sharma's clause or Mr. Borpujari clause. If we are in favor of Sharma, then next question will come to Mr. Talukdar.
Because I apprehend, my lord, that let us not, my lord, contemplate a situation unlike that, my lord, gas caker project. Lordship is so well.
No,
And
that should be very clear. We understand this.
I think in my case, Lordship, I have to find the, I think the, obviously, that every point has been concluded regarding the interest part. Lordship, one judgment of this Honorable Court, Honorable Justice Devasis Burua.
You keep it for the next day.
Oh, okay.
Something you should keep it for the next day.
he has become more
Yeah,
wise
no,
now.
but it is a while. Honorable Court Justice. So that's the.
Heard at some length for at least this matter for further hearing on. In the meantime, to put it over. Further hearing on.
It can be on 1st of October. It is Tuesday, my lord, before vacation.
First of October.
First of October.
This Lordship said that before vacation, 1st of
Before
October.
vacation, before vacation.
1st of October.
Will not try to keep a part hard for CAV for the vacation. So that's why we'll try to dictate, if not possible, too many matters, of course. Then after vacation, we'll deliver the judgment, making it CAV.
My lord.
We'll try on first to deliver in everybody's presence.
Yes.
If not possible, due to rush in the vacation period, then we'll fix it on reopening for CAV, make it CAV.
Well, your lordship is fixing it on
First
1st of
first
October.
of-
Yes. ठीक है।
And so,
But I have given a copy of the letter issued by the subdivision officer. Parley is going on as to whether the compensation can be granted under the new act. And certain resolutions were taken therein at page 2. In the past, factors such as market value and solatium were not included in the assessment, but the 2013 Act now mandates their
No,
consideration.
that's fine. That is a job of the collector.
Yes.
What is our job is, here is a dispute. They say this is an land acquisition under 1894 Act and everything was completed prior to the coming into act effect of the 2013 Act.
Yes.
Your case is that yes, certain procedures started,
Yes.
but in view of section 24 as interpreted by the Honorable Apex Court in Indo Development Authority, you are entitled for compensation under 2013. We'll have to answer this question.
And
the Rest-
authorities also.
And if we say it is 2013, it will necessary corollary is that the compensation is to be under 2013. That's all.
But my lord, whatever they are saying, the government is saying, realize the notification that I have placed before your lordship. Because the authorities also are now contemplating to give it under the 2013 Act.
Then it's matter over, then we'll say
Yes,
they are
yes,
contemplating no
That
cause
is,
of
that
action.
is, that is, that is what I placed before your lordship.
Not a part of the pleading. I am taken by surprise.
I am
That
giving
will
you a
be my
copy.
argument. Yeah.
No,
Let it be
no,
a part of the pleading.
no,
I
then
am
what
taken by
remains?
surprise.
Then what remains? Why should write a long judgment? We'll say that this is the copy, so matter has become infructuous. If you wanted the judgment or you want to rely on the copy, we'll say that it has become infructuous.
No.
Then, if you say that your grievance is redressed by the office, they are proposing to redress your grievance. Matter ends there. Why should you proceed for it hearing?
No, what I am trying to say.
Don't say
What-
officers cannot decide this position. If you say they have decided, okay, fine.
And so oblige me.
Yes.
Five and six.
Oh.
May I please, Your Lordship? In this case, Lordship, there is a similar matter, Lordship. Lordship can dispose of this matter, Lordship.
No, we know that same submission was made on earlier occasion.
He has passed on the judgment.
And they say that it is applicable. Mr. Kolita sought for an instruction.
My lord, he has only given this judgment.
Okay. Okay. So according to it, acceptable.
Page 18 and 19.
Page.
18, relevant portion.
Now fill up the blanks and give it to us.
My lord, the judgment is in such a way date is not mentioned. SLC meeting cancellation order date is not mentioned because it was a common order. So no date is required. Corrections to do it and give. Only WPC numbers and all will be correct.
So here also written communication 7622.
Yes,
Okay.
that instruction is a common one.
Come on.
Common, 17.
So except writ petition,
Except writ petition number, no other number.
okay, send the writ petition numbers and give it to him.
Much of that.
Okay, whose name? So petitioner.
On behalf of
And Kalita, on behalf of Mr. A. Oh, Kalita is here, Anjan is here.
No.
Not available.
No.
Okay, and Kalita on behalf of Mr. A. Kalita and M. Dot for respond number 4. Disposed of. But we'll get this order on next Tuesday only. I'm traveling today.
Much of that. 5 and 6.
5 and 6.
5 and 6.
Dispose of. Well, ask them to give this. All this prison is sent. Yes, I should. Yes, 7.
The respondent has filed an affidavit, they have
Admitted.
admitted.
How when can you pay?
3 months, my lord.
Hard, Mr. P.J. Saikia, Learned Counsel for the petition.
Paragraph 4.
To লিখিব 6-5. The respondent has filed an affidavit and has taken a stand that the petitioner has executed the works paragraph 4. That's why I was looking at 6, paragraph 4. Executed the work, 2 works, no? Executed 2 works as claimed and an amount of rupees 3,70,000 for execution of work at Bhurbanda BDO office campus and an amount of rupees 375,000 against the work executed where this is executed? No, total, what is the amount total? 370,000 plus 375,000 total. What is the total? Is due, and that the petitioner has completed the work in stipulated time. In view of such clear admission, the respondent authority now should pay the aforesaid amount due to the petitioner. Full stop. At this stage, MS U Das, Learned Counsel representing the Deputy Commissioner
All my lord.
or representing the respondents, submits that some time may require for final payment. Final payment, and it is expected that payment can be paid within a period of
My lord, 3 months,
3
4
months.
as your lordship pleases.
No, we do not want another contempt.
Lordship, 4 months.
Within a period of 3 months, full stop. Be that as it may, as the administrative work and sanction from finance department requires some time, it is provided that in view of the clear admission of the execution of the work and the clear admission as regards outstanding due totaling so and so, it is directed that the petitioner be paid the aforesaid amount within a period of 4 months from the date of a certified copy is submitted before the respondent authorities by the petitioner. Disposed of. Yes.
Yeah, in 13/5/2013, 22, my lord, this honorable court directed to the respondent of the APDCL Power Grid Corporation of India Limited, as well as the circle officer Haju Revenue Circle, after making a joint survey of the land of the petitioner involved in the case, with regard to said NERP SIP project, shall place before the court about the decision to maintain the minimum clearance for laying such 33,000 kV overhead cables of the for the purpose
Have you
of
gone through the
transmission
affidavit?
with regard, my lord, now they have stopped the working, my lord.
No, in this case, my lord, I'm sorry, my
They
lord,
have
we have only
executed
filed the report,
the
my lord, in our affidavit, my lord.
There was a field verification and there is no violation of any rule.
No,
by the
they-
respondents.
They have stopped this work, my lord.
Because there is strong
They
objection by the
have-
petitioner lordship
they
regarding
have-
implementation
they
of the
have-
construction of the line and stringing of the line, your lordship.
No, then we'll close this writ petition.
My-
Because they have taken a specific stand that they have taken the line within a permissible limit under the act.
Right.
So what remains?
That will support the report. my dear.
Please wait, we'll record your name. No, don't worry. Mr. Das, be here, let him be
My
here.
lord,
Yes.
actually, my lord, I have not gone through the affidavit because of my illness. So
Then
I
we
may
can
be-
adjourn
yeah,
if you
I may
illness,
be
but
given
there
some
is nothing
time
to
for-
suggest. In the affidavit, they have specifically stated what is the provision of law and what is the length, breadth, everything, and they have asserted that this is the position. So matter ends here. And it is a public project.
Yes, I know, my lord.
Then close it.
No, my lord, as per my lord, there is a Supreme Court judgment, my lord. As per this
No, no,
judgment,
Supreme
there
Court
must be
judgment
made-
is there,
must be
but
some
Supreme,
clearance, my
they
lord.
have said in terms of the act, we have done it. Until and unless you file and reply and dispute that, no, this is not there. Then we'll give you an inquiry if necessary by an court appointed commissioner, but cost will have to be given by you. So if we find that it is their stand is correct, your is wrong, then cost will have to be paid, public money.
My lord, I may be given some time.
Okay. On the
After
prayer of the
Puja
learned counsel for
After
the,
Puja Puja.
after learned counsel for the petitioner, matter stands and adjourned to enable her to file a reply affidavit to the affidavit in opposition filed by the Power Grid Corporation. Upor Lekhika heard Mr. N.C. Das, who is virtually present, assisted by Mr. A. Das, and petitioner for DD. You are for responsible, and Chaudhary for APDCL. APDCL. List of application.
Much obliged.
Have instruction, nothing is there in this
Much
petition.
obliged.
May I please your lordship.
Yes.
My lord, IA is for implementing
Hard.
as a party
We
responsible.
have objection, my lord.
For objection.
There is no, they have no Lucas Mallet in this case. They are not necessary party also.
Who are they?
They are saying that they are NGO. Their NGO is not, my lord.
What is her the name of the NGO?
My lord. NGO's name, my lord.
It says Somiti, my lord.
Tell us the name.
Koga Latola Milan Pihok Cooperative Society.
And you say that they are trying to encroach your land.
Yes.
Huh?
They have
Para-
claimed that
para-
land is
para-
allotted to them. 780.
Where is writ petition? You have seen that it will land belong to you. You are flood. We are affected. Then when flood gone,
Not yet.
river has changed its direction. Then this land now it's a cultivable. Instead of allowing you, this summit is cultivating. This is your allegation against. Why they are not necessary parties?
Annexure 4 also there.
Huh?
But
Then we'll not implead you. Party will make us, will dismiss this petition on the ground that a specific allegation is lodged against so and so, so and so. They are not made parties. Therefore, we cannot pass order against this. So therefore, it petition stands dismissed. Okay. Dictate that order. Why unnecessary object? It is your case that they are disturbing you. Heard Mr. Swenso, Lord Counsel for the petition. The present IA is filed impleadment of the applicant as respondent number 6 in the connected writ petition. In the connected writ petition, the petitioner has taken a stand that a non-existent cooperative society, namely Bhoga Lautola Milon Krishak Samabay Samiti, has started disturbing the peaceful possession over some portion of land of the petitioner, which has become suitable after erosion. The said Bhoga Lautola Milon Krishak Samabay Samiti is not a party respondent in the present writ petition, though there is an allegation against that petitioner. So dismiss or allow impleadment.
impleadment.
Which one?
Second one, I think.
Which option? Tell us. We are ready.
Second of.
Second option. Not made a party. And a said Khoga Lautola Milan Krishak Samabay Samiti is the applicant in the present IA. As there are specific allegation against the applicant, and in the event writ petition is allowed, the present applicant may be adversely affected. In the considered opinion of this court, they are necessary party for this writ petition. Accordingly, IA stands allowed the applicant be impleaded as respondent number 6. Full stop. The applicant shall furnish an amended cost title of the writ petition. You will have to give you are having a copy of the writ petition. You type it out. Amended cost title of the writ petition before the registry, so that registry can incorporate the same in the writ petition. Full stop. A copy of such amended cost title also be furnished to the to all the councils representing the parties so that they can also correct their records. I stands disposed of.
One thing is, my lord, respondent 4 is the repetition of respondent 3. That is why it would be respondent number 6. Otherwise, S7. It was observed earlier order. Obvious.
Respondent C, it will be respondent C.
Yes, yes.
Okay. Yes, there is something to be filed.
Hello, we filed the reply and I think that.
Land records of Doug number 175.
That record is awaited, lordship.
Okay.
Pleadings are complete, my lord.
Huh?
Pleadings are complete. So records.
MSS Borua, learned
SR Borua.
SR Borua, learned counsel for the state respondent submits that he has not received the land records of Doug number 175 within bracket old /401 new of village Ulubari, and they are in terms of this court's earlier order dated 27/8/2024. Accordingly, he pressed for an adjournment. Prayer is allowed. List this matter.
24th, my lord.
24th possible?
Lordship.
24th of this month. 24th.
Obliged.
For records.
Deed writer.
Without following the procedure, lordship, that license is cancelled. So last one today, understand that we will dispose of the matter, lordship, remand back the authority, interfering this order. But I have gone through the manual, lordship.
Only lordship, para 6, we have mentioned that we have called for, but he misbehaved, lordship.
Why you misbehaved?
Yes, their allegation, lordship. Now, in the manual, lordship, it is there. Here only the register has the authority. Let's me kindly have the page number. Page number 62. Rule 14. You will find at page 63.
63.
63. Register shall complete in respect of each so and so. District test of respectable deed or petition writer who may be allowed to across to the compound of the register.
I'm at page 62. Which clause?
14. 14, lordship 1. This is the authority of the register. They can.
13. I have got 13.
Page 63, 14.1.
63, 14. Okay.
So in view of 14.7, that will lordship
Register.
find at page 64. The register is empowered
Okay.
to cancel the license of the deed writer who is guilty of the disobedience of a lawful order.
Now, where is the power to give license?
That, Lord.
Huh?
This only says the rule 14.1. 14.1. Because it is a temporary arrangement.
That we understand.
And they fix the remuneration by the
See,
register.
here it is unlicensed deed writers. There must be somewhere some.
I have gone through, but no time.
Okay, we'll take it up on Tuesday. Okay? Just I want to go through it.
Okay.
Not for any other purpose. We can allow, but to have my own satisfaction because sometimes
Part 2, chapter 2 of this manual.
Hmm.
It only the clause 14 says about the cancellation as well as the fees, what it we pay.
let me do some research. Okay. Just for my knowledge, what is the provision that deed writers are given license? When there is a provision for procedure of cancellation, there must be somewhere something where license is to be issued.
I've
Isn't
gone
it?
through it, but not.
No, that's just for that, not today. List this matter on Tuesday. 70. I'm keeping this.
Obliged. We have got a matter. in court.
You both of will have got a matter every day.
Both sides, that's the whole problem, my man. Actually, a part hard matter, that matter.
Okay, no problem. When? After vacation?
No,
Or
no,
any
they have
urgency?
some urgent.
Urgency. Thursday, motion is suspended.
My lord, it can be.
No, not Thursday, it should be Wednesday. See,
Wednesday.
Thursday is a difficult, all hearing method, we give
Lordship.
preference to those methods.
Wednesday.
Wednesday, how much? 13, okay.
Actually, we are in the part third matter.
Yes, we have booked part.
Okay.
There is an interim order. there is part-
See, I'm also not unhappy. So I have done some homework because I'm leaving, that's why. Today.
Inter-
So otherwise it would not have the, on Wednesday.
Interim order until till that.
As agreed to by the learned council for the parties, list this matter on 25/9 and interim order partial.
Not 25?
Not.
No, not 25. Thursday, this Thursday.
This Thursday.
18.
18.
This Wednesday,
Wednesday.
17, 18th. Okay.
Well,
Interim order partial.
interim order will start. Safely up.